Well, thank you everybody for watching this video. I'm super excited to have Heather here today. Kristen Cooper, your mortgage planner, just providing some additional content and information so that you can make the best educated decisions and know what to expect throughout the process of whatever it is that you're trying to accomplish. So today, I have Heather Mayer here. She is an attorney at law specializing in several areas, but one that we want to go ahead and start talking about is going to be estate planning. This is huge. I talk to every single one of my clients about estate planning, but I think it's really important that people understand it on a deeper level so that they can make an educated decision from knowing the facts versus, the fear of losing money because they have to spend money to set it up or, whatever their objection is. So thank you for being here today. I know that you're super busy and your time is super valuable, so I really appreciate you being here today.
Thanks, Kristen.
Maybe if you could start with giving a little bit of your background, and then if we can jump in and talk about what is estate planning and what does that include?
Sure, absolutely. So I actually fell in love with estate planning way back in law school. So my first wills and trust class, I was like, this is it. This is for me. This is the area that I want to go into. And I was very lucky to be offered a clerkship right out of law school. So I started working in the probate court right away and had a great opportunity working in Sacramento County. So that was a wonderful experience. In law school, I worked for an estate planner, and then after law school, after my clerkship, I ended up going into a family law firm. So I worked a little bit in family law, a little bit in estate planning, and then had another unique experience where I worked for the Department of Healthcare Services for a couple of years, and then got to see the ins and outs of what happens after a person passes away in terms of medical planning. So I had kind of a broad experience there before going out on my own. It's been, 5-6 years now. It's been several years since we started our own practice. And now
Wow.
I focus on estate planning, which is really nice to have that be my primary focus. And then secondary to that, I do probate still and a little bit of family law. But the family law that I do is unique because I don't litigate family law anymore. I only do mediation and collaborative. So that's kind of where I'm at now and what I'm focusing on.
Yeah, and I want to mention, and we did a call too with your partner, Christine Young, who does more of the litigation and divorce side too. And so when you talk about the portion that you do is mediation and collaborative, in that video, we talk more about collaboration, but just kind of a brief summary of what collaborative is really just finding the right expertise and professionals to come into one room to deal with the divorce. So you can have an attorney, you can have a financial advisor, you can have coaches for the kids, for the adults. And the purpose around it is kind of keeping the family one unit. And so if there's a way that you could stay out of the court system, out of litigation, I mean, it does tend to save you more money too because you're not litigating. But if you could do it in a way that everybody can come together and find common ground in a sense for, especially if you have kids, it's going to save the family unit. Maybe not together because you're no longer together, but as parents for the children. And so it's really a unique process that a lot of people aren't aware of that's there. And so I think it's awesome that you guys do that because you do care about your customers, and that's what comes first. And you're always trying to figure out and explore where can we start that's going to be the best option before you have to actually go to litigation, which is obviously where you want to try to stay out of the court system litigation practice. So it's great. So maybe if we could start talking a little bit about what is an estate plan, what's included in that.
No problem. So similar to what you're saying with collaborative law, how we're really trying to stay out of the court system, that's the same thing that you're doing with an estate plan. So for us, it's the probate court that we're trying to avoid by setting up things that allow you to avoid that. At the most basic level, I just call it an estate plan an umbrella. So it's just a term that covers all kinds of things. So you can do estate planning on your own by setting up a payable on death beneficiary, for example. So that will keep you out of the probate court. And for a lot of things like life insurance policies or retirement plans, you automatically do that when you set up the plan. Where I see problems is people pass away. So you have a wife who lists her husband as the primary and only beneficiary on a retirement plan. The husband passes away, and then shortly thereafter, the wife passes away. Well, now we have a probate asset unless you also have your estate plan set up with a will and a trust. So that's where I'm trying to help people avoid having any asset probated, but especially large assets, because that ends up costing a lot of money, and it's a lot of time that beneficiaries may not have, or they may need access to those funds right away to pay for medical bills or for cremation or burial plans, things like that, where they need immediate access and they're unable to get it because the money has to go through probate first. So my goal is to do kind of the basic will, trust, advanced healthcare directive, power of an attorney with people that come into my office, because that is going to keep your loved ones out of court and make sure that your estate is intact for them. So to kind of like piecemeal that out, when we're talking about a will actually still goes to court. And I think that's one of the things that people are most surprised by, is they're like, oh, I have a will. That doesn't actually stop your loved ones from going to court. It simply directs how you want your estate to go, and then also sets up a guardianship plan, which is really important, especially if you have minor children. So not to say that a will isn't important, but I just think that it's a common misconception that if you have a will, you're not going to end up in court, and you are. So with that will.
And a will can be contested still by others, correct? A will can still be contested.
Yeah, it can absolutely be contested. So with that will, we also do the revocable living trust. And the reason they still go together is because your will ends up becoming a simple pour over will in that instance. And the pour over will says, all of my assets are going to my trust. So if you fail to put an asset into the trust, then your trustee or executor can still go to court and ask permission of the judge to move that asset into the trust after you've passed away, which isn't that common. We probably see it a couple of times a year, but it still does happen. You know, if you have a large asset, you purchase a home, you forget to put it in your trust name, and then you pass away, there's still that backup plan. So it's important to still have a pour over will, even though you're setting up a trust. So the trust itself is kind of the thing that I focus on, right? Because that is where we are transferring assets from your individual name into a trust name. And then the trust continues even after you've passed away. So you are replaced as trustee, but your assets still stay in the same spot. And that's why they don't have to go through the probate court and then be distributed to your beneficiaries. Your trustee simply, or your successor trustee simply takes over your role as trustee and then is able to follow your instructions that you laid out in the trust.
Yeah, because what I find, and kind of to elaborate on probate, what I've found, at least with my clients, is probate means that if the person that's on the asset passes away, there's no beneficiary, the court has to distinguish where that property goes. They do follow like a hierarchy of where it goes as far as the family tree, but it could take well over a year for the courts to establish where that asset goes. And I know that they could take up to like 30% of the asset value as fees to be able to go through the process of probate, which I think is what a lot of people don't understand, is what if on that hierarchy of where that property goes, it's the person you don't want it to go to, you know, and that's where it's going. I mean, you never know. And then it filters down. But the bigger thing is, even if it does, and you're like, you know, they'll eventually get the money, a lot of it's going to be taken out of fees for it to go through the probate court. It's huge. And so with my clients, especially because owning a home, the only way to protect a home from going to probate is to have it in a trust, correct?
So right now, there's still another way that you can set it up with a transfer on death, but that is going away. And in my experience, it's only caused problems. So you could do a transfer on death deed now through the end of the year, but it's going away, and it's going away for a reason. So I wouldn't recommend it. It's not something that I draft, but there is that tiny possibility for the next couple of months. Other than that, you can have somebody listed as a joint tenant on the property. And that's pretty common with married couples, right? So if you have two people listed and the house is in joint tenancy, one person passes away, the survivor gets 100% of the asset. Now, in a lot of cases, I actually have couples with separate children. So what they end up doing is separate trusts, and each of their trusts owns 50% of the property. And that truly is a great way to protect their one half, and then it immediately goes to their children. Obviously, you can expect that that creates problems too. So one of the things that I say when I'm talking about creative estate planning is tell everyone, tell your beneficiaries what's going on, share with them what your plan is and why. And then if everyone's on the same page, then it really puts those beneficiaries in a position where they understand what your thought process was, and it helps them to not want to contest something and not want to go to court because they understand why you were doing what you were doing. If you didn't do that and you didn't have two separate trusts, you can do one joint revocable trust and have a plan set up for that property. Or like I said, if one person passes away, the survivor gets 100%. So that's another way.
Yeah, another thing too, I have clients that, often like, well, when I pass away, I want my property to go with my kids, so I'll just add my kids to title. There's so much risk that comes with that I explained to them. It's like, yes, that is an option, but what if there's judgments, lawsuits, debts that are still outstanding when you pass away? All of that could be attached to the property. So maybe, what's your experience? What have you seen with that?
Yeah, so I think the biggest one that I've seen is where there was a child support case, and one of the parties, one of the children, they didn't pay child support for a significant period of time, and then ended up where the person who was supposed to receive the child support was able to get a judgment lien against a property that they were on with their parents. Now, it was intended to be an inheritance, so yes, it was intended to be that child's property in the end, but the judgment lien attached right away, and it was a significant amount of money because the person just hadn't been paying their child support. And that does happen, and that's one of the common misconceptions with child support is, oh, I had a side agreement with the child's mother or child's father and we weren't going to do any support. That doesn't mean that the support went away. You have to go to court in order to fix that. So if you don't go to court and you don't have a court order, whatever the last court order was still stands. And if you're in a position where it's racking up, it's also racking up interest. And so that to me is one of the biggest risks that we see, right, with the crossover between practices. But aside from that, I mean, similar concept, right? The child gets in a car accident, ends up being sued. They don't have an umbrella insurance policy. And then again, there's a judgment that can be placed as a lien against any property that that child owns. It doesn't matter that they never paid for the property. It doesn't matter that they're not on the mortgage for the property. Their name is on title, and so we can attach a judgment lien to that title.
Yeah, which is huge. And I mean, beyond that, there's so many different like capital gains and things that they need to talk with their CPA about, because inheritance gift tax is completely different if you're an owner on a property versus inheriting it. So there's so many different factors. And I think that's what a lot of people don't understand. And I think that I know in our field, in the lending side, there's a lot of lenders that don't even address it because it's not in their field, that they just are like, it doesn't matter. But I want to make sure that my clients are set up for success and understand that there's a lot of cost to not setting up a trust. The cost for setting up a trust is so minute to the cost that it could cost you down the road if you don't. And I think that once people understand that, it's easier to make an educated decision to set one up. But also included in the estate plan, like you said, like there's medical directives, power of attorney, especially if you have kids. You want to address, what do you want to happen to your kids? Who do you want, to take care of your kids? I know for me, I mean, beyond the money, that's probably the biggest thing for me was my kids in the trust.
Right. And, another piece to that is if you have kids and you're no longer together with their mother or father, you may not want that person managing the money for your kids, right? So you can imagine the scenario, and I was just speaking to someone the other day about this, where we have a mother and a father, they end up getting divorced, and then the father passes away. Well, what happens to his money if he doesn't have an estate plan? It's going to go to his children, but the guardian of those children is going to be the other parent. And so that parent is going to be managing the money until those kids reach 18. And, people get divorced and separate for a reason. So there's a reason that you're not with that person. And usually you don't want that person having control over your estate. So even a simple will in that instance would have fixed that problem. But a trust would be better, because then you could hold the money back until a specific age. So you could say, I don't want my kids to have their inheritance until they reach 25, or perhaps at 25, they receive half of what's left, and then at 30, they receive the other half. Another thing I get asked is, oh, what about college? I want to make sure that they have money for college. And if they're going to school at 18, they're going to need that money. Well, you would set up your successor trustee to have the power to pay for that college education. And then you can be more creative if you want. You can throw in things like, oh, the trustee can give them money to have a down payment for their first house, or to pay for a first wedding, or, you can put as many provisions in there as you want to beyond the basics. Or if your trustee is someone who's, a brother or sister, a best friend, you feel like they know exactly what I would want to have happen, I trust them, that's okay too, to leave it a little bit more broad.
Yeah, I think that's great. In my trust, that's what I set up too, because I have seen a lot of people, a lot of kids, they're 18, get tons of money and it's gone, and I deal with a lot of people, with inheritance and stuff, and I see it. So I put in those provisions, and I like being able to do that. And I am, from a multi-house, I went through a divorce too. And so I want to be able to dictate where that money goes. So I think it's really important that people see that. And I don't think that people realize that. That's just the thing, is who's there to tell them? How would they even know that that's something to think of?
Yeah. And so that's one of the things that we talk about with our divorce clients is, hey, you're going through this situation, at least keep it in mind. So, you may not feel like you want to do it now, but keep it in mind for the future, because, it's like, as we've, experienced things in our practice, we've seen it happen, right? This isn't just, oh, this is something that, we've heard of. It's like, no, we've seen it happen. We've had clients pass away during the divorce process or right after the divorce process, or, you know, even with my probate clients where it's like one spouse passes away immediately thereafter the other one does, and where they thought they were going to, you know, be able to avoid probate, their kids didn't end up being able to because the second spouse passed away so quickly. And these are just personal experiences, right? Where I'm like, I've seen this happen. I know how devastating it can be for families. And that's where I want to step in and try and help now before they're in that situation. And kind of same thing with those additional documents, right? The healthcare directive, the financial power of attorney, you're still just trying to avoid the probate court. So if you don't have those documents, then your, you know, loved ones are going to end up stepping in to get a conservatorship. So if you have dementia and you're, you know, falling for scams and spending money or, you know, taking all this money out of your bank account, your kids can't just stop you. They have to go to court and they have to file for a conservatorship in order to manage your money and also make your healthcare decisions, unless you've already set up those power of attorney and advanced healthcare documents. So those are just simply nominating an agent to step in for you if you lose capacity.
Yeah, which is huge. I mean, I think that that's something we don't really consider either, which is, you know, it's huge what you want to happen to you. So I think that that's important too. What, at what point would you say is when really someone should look into setting up a trust?
So for me, if you have assets over the small estate affidavit, which right now it's $166,250, then you're in a position where you're going to want to set up a trust automatically. So it's, you know, in California, you buy a piece of property, the gross value is going to be over that. It's pretty hard to be under it. So for me, that's kind of your immediate, if you own property, you should probably look into getting a trust. And then the other thing would be if you have kids. So if you have children that either can't manage their own finances or are minors and you know, wouldn't want somebody else to be stepping in and managing it for you, set up a trust. List the person as the trustee who you would want to manage your kids' money if something were to happen to you.
Yeah, I agree. And a big thing that I tell my clients too is it's not even about you having a trust. That's super important, but your parents. If your parents own property or have assets, you need to ask them, hey, do you have a trust set up? And I'll use my own example. I swear by trust. And my dad passed away, I think 5 years ago now. And I found out that my mom did not have a trust set up. I almost lost it. Because mind you, we're 5 kids. I'm the middle. So I'm like, I don't want the responsibility of having to deal with, you know, whatever the trust is. So I just paid for it and told her, go set up your trust however you want to set it up. I don't want to like be in that position to deal with it. So I'd encourage you too, it's, you know, it's just anyone, if you have parents that are still, you know, living, have them set up a trust so that you can honor what they want to happen and also not have to deal with the consequences of dealing with probate too, or having family arguments. It's just not worth it. It's just not worth it. So I always encourage my clients when I have the conversation about setting up a trust also with your parents. It's a good time. And I know a lot of people don't want to bring it up, but it really is honoring them by bringing it up because they may not even be thinking about it. And they may have a certain way that they want things done. And how would you know unless they set that up?
Exactly. And there's lots of things that people come to me and say, you know, oh, well, I'm planning on getting my parents' house after they pass away, and my sibling's going to, you know, be the beneficiary of a life insurance policy to offset that. Well, if they don't have a trust that actually says that, that's not what's going to happen. And then beyond that, you know, if someone were to say that to me, I would say, well, is the life insurance policy payable to the trust? Because if it is, then we could offset. And if you're keeping that real property, you may be able to keep the entire basis because it's 100% going to you. And then that life insurance money that's offsetting is 100% going to your sibling. So you could keep the same, you know, property tax under Prop 13. You could keep the same basis of the property, rather than if you're only receiving half and you're buying out the other half from your sibling, then you're only able to maintain half of those things. So there are creative things that you can do if you talk to your estate planner about it ahead of time. And you say, this is what our intention is. Are we doing it the right way?
Yeah. And how often do you think if someone has a trust set up, how often should they be reevaluating it, or at what point should they be reevaluating it?
So it's really dependent on the person. I have some clients that come in every single year because their lives are just up in the air right now, right? Their beneficiaries change every year. But any big life event, you're going to want to talk to your estate planning attorney, because if you have a baby, your opinions may change, your guardian may change. If you lose a loved one, you may need to be updating the document because they may be included in there and you may change your mind. So sometimes people say, oh, well, you know, this $5,000 gift is going to my sister. If she passes away, the gift goes away. Well, if she actually does pass away, you may say, oh, I'd really rather that go to my niece and nephew now. So you need to take a look at your estate plan and say, okay, well, what did I write then when I was just imagining these life events, you know, versus now when they've actually taken place. So a death, a birth, a marriage, a divorce, all of those things are really important. So big life events, you let your estate planning attorney know, because there's also consequences that may be unintended by not doing anything. So for example, if
Yeah.
you do get married, then you're in a position where your, you know, estate plan is probably going to change, right? I mean, you may want your new spouse to have access to your house if you were to pass away. Maybe you don't want that new spouse to receive the house outright, but you want them to be able to live in the house for a life estate. So there are different things that you can set up and make sure that take place after those big life events.
Yeah, I think that's really important, and that's why I wanted to touch base. And if you didn't know a lot of this and you have a estate plan, you probably should go in and reevaluate it and look at it and just make sure that it's set up on there the way that you want it to be too. So anything else that you think we should add that it would be important for somebody to know that does not have an estate plan but is considering setting one up maybe?
I think you touched on a little bit earlier, just the cost of probate, the cost of going through that process with the conservatorship side separate from, the probate side. If you were to pass away without a will and a trust, it's very expensive. Our estate plans, we do flat fees. So if you're a couple, it's $2,000. If you're an individual, it's $1,500. And that's just such a fraction of what I'm seeing on the probate side. I mean, I've seen probate cases where it's upwards of $20,000-$30,000 at the end of the day after it's completed, and that's not even a huge estate. So that's somebody who lives in Sacramento County, has two real pieces of real property, and that's it. They set up everything else correctly except for two houses, and it just ends up costing so much money. Whereas if they had set up a trust ahead of time, then their beneficiaries wouldn't be in that position. They would have had immediate access to the funds. They wouldn't have had to go through the probate process, deal with a judge, deal with a probate referee, right? And then also open it up for exposure, in terms of having everybody see what your business is. One of the nice things about having a trust is that it's private, it's confidential. Nobody gets to see what you wrote in it until you've passed away. And even then, it's only your heirs and beneficiaries and trustees that would have access to that information.
Yeah, I totally agree. And I know price is obviously, when you're paying for something, especially I have clients that are purchasing a home, they're using a lot of their money for the purchase, and we want them to have an emergency fund. But especially for people that are refinancing right now and skipping a mortgage payment, I always tell them, use that skipped mortgage payment to invest into the property, protecting your assets, use it to set up a trust. Because it's not extra money that you're spending. You would have already been spending that money. So I just, any way that you can, even for people that, just don't have extra money or don't want to spend their savings. If you have a 401k, I know you don't really want to touch it, but take a small loan from it to set up the trust and pay it back quickly. You can pay monthly payments. So there's different ways to be creative to be able to get it set up so that you're protected. And that's just one thing that we don't want to really have to worry about is our legacy, especially when we spend so much time and effort into building it over the years. We want it to go where it is. And so thank you for sharing the information on estate planning. I think that it really puts it at ease as to what does that look like, and you really address kind of the pros and cons. I mean, I don't really know any cons against it other than if you don't need it because you don't have enough assets, don't set it up. But there's so many cost factors that come into it that it's just going to be painful for those that you love that you leave behind when you do pass. So thank you for your time today. I really appreciate it. And then I also am sharing on here too. So you are part of the Mayor and Young. You both are partners, you and Christine, and so you handle family law, estate planning, probate law around that. So family law, divorces, mediation, probate, and estate planning and all that around there. So if anyone's looking for help or needs someone to help them with that, highly recommend that you reach out to them. They're both amazing. You can Google them. You can see they are amazing, great reviews. Trusted advisors, which is the type of people that I work with, the type of people that I want to bring on here and refer, because dealing with the wrong person can cost you even more. So thank you for your time today. I really appreciate it. I know that you have a lot going on, so I appreciate your time.